Kagawa, I would first want to say that when we talk about this bill and the provisions of this bill and whether or not any aspect of it may be preempted, we have to be very specific. We can't just say this bill is preempted or this bill isn't preempted. That's meaningless. This bill contains a lot of different provisions that have a lot of different effects, and I think you have to look at them individually. And then as to whether any particular aspect of it is or is not preempted, that's a very specific analysis. For example, if you want to say, are there aspects of this bill that are preempted by federal law, aside from asking, well, which provision are we talking about, I would say, which federal law are you talking about if you say this is preempted by federal law? Well, the major federal pesticide law is FIFRA, and the Supreme Court decided 30 years ago in a challenge called Wisconsin Public Intervenor versus Mortier. I'm sorry, this was about 20 years ago, that the counties do have the right to enact ordinances that restrict pesticide use. It was I think an analogous situation where a county said, if you want to be able to spray pesticides, you need to come to us for a permit. We have the right to regulate and so forth. And
which county was that?
This was a county in Wisconsin. Okay, and the person went and asked for the county for a permit to aerially spray his property. County said no, and he challenged it, and it went all the way up to the U.S. Supreme Court, in which he said, this is preempted by FIFRA. The county can't do this. Supreme Court said, no, you're wrong. He said, they said that FIFRA is not a statute that generally, other than for labeling requirements and packaging requirements, FIFRA does not have a comprehensive statutory scheme that preempts local ordinances, and in fact, it simply does not purport to do that. And I would add that at that time, former Attorney General Warren Price, on behalf of the Waha'a administration, submitted an amicus brief to the Supreme Court forcefully arguing that, in fact, FIFRA doesn't preempt, and he was right.
Okay, well, I'm kind of catch more topics, so thank you for that response. So there is one in Wisconsin that you should
Well, that's the U.S. Supreme Court, so that takes care of the whole issue for the whole country.
Okay. Are you familiar with HB 673, just passed this past session at the Hawaii State Legislature, Act 105, regarding pesticide use and posting online?
Yes.
Does that take care of some of what our bill is asking for?
When you say take care of it, does it address the same concerns? Does it preempt?
Yeah. Does it? I mean, why would the county do the same thing that the state is already doing when they manage pesticide use?
Well, I think the question, as I hear it, is to the extent that the state is in fact requiring exactly the same thing, then I don't know the need for having two bills that do exactly the same thing. To the extent that the county wants to do something that the state law does not require, the question is, does the state law preempt the county from doing that? And I would say no.
No, I'm not on preemptive on that. I'm just saying, does that bill satisfy reporting of right to know what's being used? It says the department shall publish on its website all reports received by the department regarding restricted use pesticides in the state.
Well, the question is, as I read the county bill, yes, and there is a little more information than that is being requested.
Okay.
So
there's a difference. Okay.
So there is a difference.
All right.
Yes.
The other.
And there's also the county, as I understand it, also would like certain information to be made public that may not be public under the state law.
Well, I guess I'm, to stay out of. I know what you're saying is that we can do it. You have a good feeling from your experience with Earth Justice But, you know, the county of Kauai, we don't have a pot of gold to be the first one to, you know, really challenge the laws and, you know, go through a long court battle and you know, put our taxpayers on the hook. I think what I really want is that if we have, you know, facts, we have strong arguments, that why don't we just present them to the State Department of Ag, to the State Department of Health, to you know, the EPA, to our congressional delegation, to our governor. I mean, we already have a bill in place here that allows the State Department of Ag to post online, you know, the right to know what restricted use pesticides are being used. All reports, it says, all reports received by the department.
It doesn't say what reports are required, does it?
And I guess, you know, all reports may not be the same reports that, you know, are intended by authors of this bill. But I mean, you know, there's a start there that just passed this session, and you know, I know it's kind of difficult right now. It's only been a month since July 1st when it became in law, but I know it's hard to say in a month how successful that has been.
Well, I'd also point out that state legislation allows the companies to decide for themselves what are trade secrets, and they don't have to, and the public is never going to see that. And the industry has a long history of calling everything that they don't want the public to know a trade secret.
I understand. Okay. Well, I mean, so that was what I mean. I really was looking for is that answer actually. That you know, that could be a reason. I'm good for now. Thank you.
Thank you, Councilmember Kagawa. Councilmember Raposo.
Thank you. This is a pretty awkward situation. It's like having a trial before the trial. It's like kind of how I feel. We're having the both sides attorneys up here and our county attorney not, and yet our attorney is our county attorney, not any of you. So this is pretty bizarre. I don't think this has ever been done. But I appreciate this, and I appreciate you guys' willingness to be here and testify. I just really do want to follow up on Mr. Kagawa's question about the proprietary, or what you call trade secret information. The state's statute state that the company can determine what's proprietary. How would the county, and this question is for all of you, how would the county be able to mandate that they turn over trade secrets? Well, we can start with you.
Okay. I'll cite another case that this one actually was about 30 years ago, in which Monsanto sued, and this one also went up to the U.S. Supreme Court. The EPA at that time was requiring certain information that included what Monsanto considered to be trade secrets. And EPA passed some regulations saying, if you want to register your pesticides under FIFRA, you must provide us with the following information, and we may, in fact, we likely will disclose this information to the public. Monsanto said, you can't do that. That's going to be a taking of our intellectual property because these are our trade secrets. Okay, so the Supreme Court said, in that case, Monsanto, you're wrong. If, to the extent that the EPA has told you in advance, here's what you're going to be required to do, and this is the price you pay for doing business, you can decide whether or not you want to do business, and if you don't want to, well, you can sell your products overseas where the laws may be different. But if you want to register your pesticide in the United States, you know in advance that this is what's going to happen to the information that's being asked of you. There's no secrets here in the sense that you're not going to be surprised the public's going to find out. If you don't want to do it, don't do it. But the EPA can require you to do it as a condition.
What was the court's ruling?
The court's ruling was that the EPA could, in fact, make this requirement, and it did not constitute a taking of Monsanto's property.
And that would, in your opinion, be sufficient for this county to require?
I think that you would.
Because I don't know.
Well, I think you would have to look more specifically at the ordinance and what its effect would be and the type of information we're talking about and so forth. I think as a general principle, the county can require information like that trade secrets as a condition of doing business in Kauai. However, you do want to look at whether the information that is being requested, the trade secrets in particular, how closely related is that to public health? Is it something that bears a close relationship, or can you protect public health adequately without requiring disclosure of certain trade secrets?
Okay.
I think that's an important
That's
principle.
fine. And I understand it's very difficult to get, legal opinions, if you will, in a 10-minute period, but I'm just trying to better understand some of the arguments. I'll ask another question, and then if you could cover both topics in your response. The issue here.
Well, what my colleagues have just said has very little to do with preemption law. It has to do with their view of what they think the council might be well advised to do. But as to whether the council is entitled to do something other than that, that's a matter of what the law requires in terms of preemption. The state has certainly not said, this is how we want uniformly and exclusively throughout the state of Hawaii to, notification of pesticide use to occur. If they had said that clearly and said, we don't want any of the counties to get involved in this, I would agree with what they said. They did not say that. They said, here's what you're required to do under state law. That's all they said. Now, and I want to make one thing clear here about preemption under state law. After that case, that Wisconsin case about FIFRA that I mentioned that happened decades ago, the chemical lobby went all around the country and lobbied to get express preemption laws integrated and pesticide preemption laws into state law. And they've succeeded in about 41 states. Hawaii is not one of those states. If you go to one of these 41 states, you will see language in their state law that says very specifically, no city, town, county may adopt any ordinance that restricts or in any way regulates pesticide use in all of these different ways, including notification and all these other things. Basically what's happening here is Hawaii doesn't have that language, but the industry is trying to suggest that that preemption exists anyway, even though the legislature has never actually done that.
Thank
Yeah,
you
I
very much.
apologize, yeah.
Do you want
To get into rhetoric about what will and will not happen to the seed companies, I haven't seen any economic analyses. As far as I can tell, it's just lawyer talk right now. If we're talking about whether the county can, in fact, enact a moratorium, to me, the legal analysis is, if they do that, would that affect an unconstitutional taking of some kind? Well, again, I would look to the U.S. Supreme Court in the Tahoe Sierra Preservation Council versus Tahoe Regional Planning Agency case. This was only about 10 years ago. Supreme Court held that a moratorium on all development for 32 months during the process of devising a comprehensive land use plan did not necessarily constitute a taking. It really depends on a balancing between what is the actual impact of this moratorium. It's a fact-specific balancing inquiry. What exactly is the impact? What is the need for it? And so forth. Bill 2491 grandfathers in existing production, and it has this particular ordinance has health and safety purpose. The purpose of the moratorium is to allow more comprehensive planning. All of those factors weigh against the likelihood that this would be found to be a taking. Thank you. Well, I think the sort of wholesale dismissal of these provisions as takings without any analysis is really, it's just meaningless. Takings law is very fact-specific, particularly when you are getting into the realm of regulatory takings where you are not depriving someone of all economic use of their property, where you are restricting their use of property in various ways to protect public health. there is a burden that the property owner is going to have to overcome to establish a taking. And I think in these cases, it's going to be a very stiff burden that I think the companies are going to have a hard time meeting.
So you think a moratorium, EIS permitting, and open-air experimentation likely to be sustained?
Well, let's take them one at a time. I'm sorry. If we're talking about disclosure, I mentioned the
pesticide spraying.
okay. I mentioned the Monsanto or Ruckelshaus v. Monsanto case, which deals specifically with this issue, and I think you'd have to start there, where the Supreme Court said that requiring disclosure, even for public dissemination, is not necessarily a taking.
Okay, so it has a chance in court.
I think it has a very good chance in
Okay.
court. Buffer zones, as to whether those are takings, has everything to do with the extent of the burden, the extent of the impact, and the purpose. You know, if in effect you are going to be taking away all economic use of their property, that's a real concern. On the other hand, if you are not, if you are leaving them with a ability to use their property to some meaningful extent, it's much less of a problem. In terms of you know, federal preemption, I would challenge council to name any federal statute that preempts any of these things.
Explicit or by,
Either
yeah,
implied or
or
express.
okay.
I don't believe it.
Okay.
I've been litigating genetic engineering cases for 10 years. I have yet to see anything approaching express or implied preemption of things involving genetic engineering.
okay. What about dust?
I'm sorry, what about it exactly?
Do you think we can regulate it at this county level?
You have an ordinance that specifically empowers you to do so.
And the Right to Farm Act doesn't
The Right
change
to
that.
Farm Act, well, let's be very clear about the Right to Farm Act. The Right to Farm Act was expressly intended to preclude nuisance lawsuits, not nuisance legislation, ordinances, or everything else. In fact, it's very clear in the Senate report that underlay the passage of the Right to Farm Act. It says, quote, "The purpose of this bill is to protect agricultural operations from lawsuits charging that the operation is a nuisance." And the committee report goes on and on, talking about how it's designed specifically to deal with lawsuits. Has nothing to do with this ordinance.
Thank you very much.
And I'm going to start with that right to farm bill. You just said it, and so I'll ask the attorneys, have you seen the committee reports that said the purpose of this bill was for nuisance lawsuits? And the committee report where the committee specifically was asked as one provision to truncate the county's authority and said, quote, "Your committee believes that counties either through zoning laws or other ordinance should be permitted to make laws regarding agricultural uses." That's in the legislative history.
Right.
So are you aware of that?
Yes,
And why isn't that germane?
because it is germane.
The farm law anticipates production agricultural activities,
Yes.
that the purpose was there for production.
It doesn't distinguish between what you want to call agricultural production and other types of farming.
Well, I don't even know if it's farming, it's research. And I've had a lot of farmers write me and say, that's not farming. Farming is when you produce a product to sell to someone. So in Hawaii revised statutes and my own research of this, and all of these issues are, you know, they're specific to this bill, but they're also about, you know, what we've talked about here, 10 years or more, what are the county's authorities. And in Hawaii, my impression, and what I've heard from other legal scholars, is we have a unique powers in Hawaii as counties compared to other states. We have a unique constitutional mandate at conservation, and we have specific responsibility to protect the health and safety of our citizens, correct? That's all in our Constitution and HRS.
Every government has some responsibility to protect the health
So
and safety.
HRS 4617, and I want to read this because this has been very meaningful to me throughout my time as a lawmaker. Any provisions of law contrary notwithstanding, the council of any county may adopt and provide for enforcement of ordinances regulating and prohibiting noise, smoke, dust, vibration, and odors which constitute a public nuisance. No such ordinance shall be held invalid on the ground that it covers any subject or matter embraced within any statute or rule of the state, provided that any conflict between a statute or rule and ordinance, the law affording the most protection shall apply. Protection, I'm sorry. And so, you know, I read this and I said, and I read the Constitution and I took an oath. It says you take an oath to protect the health and safety. The Constitution says you're to focus on the INA and conservation. The HRS says you have authority, and if your laws are more protective than the state's, county, you trump. Now that's unique to very few states, like you've said. I'm sorry, I forgot your name, Mr. Isikoff. You know, many states have specific provisions that say, counties, you can't do this. Ours actually says you can, and if yours are more protective. Now that's my read of this. What have I got wrong? Right on the mark.
Well, I would agree with that, and I would go a little further in saying that 4617 also carves out specific exception for dust, or I should say burning, cane burning. Essentially, it says counties, you can't do that. Now, if the legislature intended to have other exemptions, they would put them in there. But there's one exemption for cane burning. That shows the state is preempting the counties on that subject. But everything else is fair game.
About Act 105, that was D. Morikawa's bill. It was the third or fourth year I testified in favor of that bill. And unlike us, who have rules that say you can't change the intent of a bill, the state legislature doesn't play by those rules. Unlike us, that says if you're going to make a change, the public needs 7 days' notice. The legislature doesn't play by those rules. So Act 106, my last testimony, that it was amended so poorly that it changed the whole intention and took away the author's intention. And so it's just so ironic. D must be that now that's being cited because there was this bill that would have required some of the things from the state. That's why we're here, because the state has refused to do these things. And to have that bill that got just totally, I'd really encourage all of you to look at the legislative history of that bill and at the testimony, because to have that now cited as saying, oh, the state has a regulatory scheme is just incredible. Yes.
Well, I just want to comment, the assumption that if the state has a law on a subject and says, you know, here's what you can't do, or what we are telling you you can't do, or something, or that you must do, that this somehow preempts the counties is just wrong, okay? It's just wrong as a matter of legal analysis. In order to preempt, you have to find either express preemption, implied preemption, or a conflict. And if we're talking here about implied preemption, you have to look for a comprehensive state regulatory scheme that shows an implied intent to be exclusive and uniform throughout the state. Okay, so it has to be comprehensive, and you have to look for some indication that the state actually intended to be exclusive. You can't just say, because the state did this, the county can't.
I think